Hello, everyone. Thank you for joining us. Okay, well, there still might be a few more people joining, but I'll go ahead and get us started. I'm Noah Joseph. So for all of you that joined us on Wednesday for the 101 segment of this, you obviously know my face, and thanks for coming back for the second segment of this, 102. And I'm still letting more people in, so apologize for pausing here. I want to make sure everybody can get in. Okay, so just want to introduce the speakers for today, and then we'll just get going. So we have two speakers, Kelsey Thomas, who is a expungement project attorney with Legal Aid of Western Michigan, and then Ashley Russett, who is an associate attorney with Houston and Van Helmont. And correct me if I did not say that correctly. Ashley is also the vice president of the Grand Rapids Bar Association Young Lawyers section, and representative in the representative assembly for the state bar representing the 17th Circuit. So thank you to Kelsey and Ashley for joining us. And I'm going to turn it right over to Kelsey, I think, to get started. So thanks a lot. I guess before I turn it over, I will let everybody know this is being recorded, and I'll be sending out some materials after this. It probably will be Monday before I send anything out. And if you have questions, feel free to put them in the chat. I'll be monitoring the chat throughout today. So please ask any questions you have. And then with that, I will now turn it over to Kelsey.
Right, thank you, Noah. As Noah said, on Wednesday, they discussed the new clean slate statute. As a quick recap, in April of 2021, eligibility for expungement was significantly expanded, which is really great. As a general rule, those with no more than 3 felony convictions and an unlimited amount of misdemeanor convictions can now apply for an expungement. If you missed Wednesday's meeting, definitely go back and watch it if you are unfamiliar with the statute, because there are many exceptions to that general rule. Today, Ashley and I are just going to walk you through filing the actual application all the way up to attending the expungement hearing and our case process here at Legal Aid. And with that said, I'm just going to hand it off to Ashley.
All right. Hello, everyone. I'm Ashley Russett. I'm not at all a criminal attorney. I don't practice criminal law. So I just want to let you know how easy this is, no matter what sort of law you practice. When we start with a case, the first thing you want to do, obviously, is check the eligibility of your client and whether their crime is of a nature that can be expunged. The easiest place to start is to pull their iChat, which, as it says on the slide, Internet Criminal History Access Tool. And that's accessible online through the state of Michigan Police website, or if you just Google iChat. It costs $10, and what it will do is it's supposed to pull an entire record of an applicant's criminal history and let you know the date that they were convicted, the court, the prosecuting attorney. Those are all important facts that you'll need for your application. But what you'll need to know is that that's not always entirely accurate. I have had a couple clients who the iChat actually did not identify a crime that they knew they were convicted of. So definitely speak with your client and ask them to hopefully remember of all the crimes that they are convicted of and what courts they were convicted in, because a second step is to reach out directly to those courts. If something is not popping up on the iChat, call the court clerk in the court where they were convicted and see if they can pull up that record. I think we're going to the next slide then. On to the next slide, in relation to what I just said, you will actually need a certified copy of each conviction anyway. So you will need to speak to the court. Usually you have to get it in person. They won't usually send it to you in the mail. I've had some court clerks email me a copy just so I can see if they're eligible before having them go and pay for it, which can be a good step if you want to avoid payment, making that first phone call. But they'll definitely need a certified copy after determining they're eligible. which they will then attach to their application. And on to the next slide. In addition to needing the certified copy of the record, you will also need to get your client fingerprinted. And that can be conducted at the Michigan State Police branch, or any police station really should be able to do it. Sometimes they're out of the fingerprint cards, so maybe have your client or you call ahead of time to see if they have any of the fingerprint cards in the office, so they don't waste a drive out there. And I can't recall right now, maybe Kelsey can clarify if there's a cost to be fingerprinted. I believe there is.
There is a cost at most local police departments. The Michigan State Police are just fingerprinting for free right now. So that's a good place to send clients.
Okay. Yep. And so they'll want to get their fingerprints and bring that copy with you. All right, next slide. So first you got your certified conviction, then you've got your fingerprints. The next thing is a $50 money order. Now you only need one money order despite having multiple applications. So correct me if I'm wrong there, Kelsey, but I believe, so I'm sure you learned in the first class, but you file an application in the court that the conviction occurred. So I've had a couple clients who had convictions in different courts. And so you have multiple applications, but you only need the one $50 money order. In addition to that money order, I haven't had a court ask for this, but it's certainly important to speak with your client and ask them about their post-conviction behavior. The judge will ask them to make a statement on the record, usually about what their post-conviction behavior is. And especially if they have a crime that you're a little nervous about, having any sort of written documentation demonstrating that they've been, I guess the best way to put it is a productive member of society since then, you know, their employers, their places where they live, people that they interact with, if they're in a church or if they're a part of a community organization, anything that someone can put in writing to say that this individual has been actively engaging in their community in a beneficial way will certainly go to support their application for conviction. Regardless of whether you get the written documentation, you do want to talk to your client and ask them those facts, because they will be asked them in court, and that'll get their gears going, thinking about what they've done since then. And I'll pass it off to Kelsey.
All right, so something to just be aware of when you're filing the actual application is that there is 3 different types of forms. The first is by far the most common that I use. It's the basic MC-227, the application to set aside conviction. The second is just for misdemeanor marijuana convictions, MC-227A. And the third is the application for victims of human trafficking. I personally have not filed one of these, but we are going to talk about it a little bit today, just so that you are aware it's out there. And so start by filling out the application. Multiple convictions can be placed on one application as long as they belong to the same court. Convictions from separate courts need to be filed on separate applications. As you're doing this, you definitely want to call the court that you're filing in to check on their procedure. Each court is doing things a little bit differently with these. And if you do receive a hearing date, when you call the court to check on their process, fill out notice of hearing and proof of service on page 3 of the application. Some courts don't give you a hearing date at the time of filing. So if you receive that at the end, make sure to send out notice of hearing and proof of service if the court does not do that. Once you have page 3 filled out, you're going to want to make 5 copies of the application and 5 copies of your certified copy of conviction. And you will be sending that out to the Office of the Attorney General. You can go to the next slide, Noah. Sorry.
That's all right. Before we go on to the next slide, there is a question in the chat that now is a good time to ask. Is the case number on the application the same as the original conviction case number?
Yes, yes.
What if there are multiple cases on one application? What would someone do then?
So if there are multiple case numbers, I fill out with the most recent case number at the top. And on the actual application, it asks if this application includes multiple case numbers, check yes. And then just put the rest of the case and cases and convictions into the box on page 1. So once you have your 5 copies of your application, you just want to first file a copy with the court. Send 1 copy to the Office of the Attorney General, the prosecuting attorney, the Michigan State Police with your fingerprint card and $50 money order, and keep 1 copy to yourself. And then we had another question that was relevant to that second question.
Yes. So do you use the crime code for the charged crime, even if they pled to a different crime?
You always use the information for the convicted crime. So the CTN will be on the certified record of conviction, and it will also be on the iChat. So that's where you're getting that. I think she's asking about the CTN and the SID and all that.
Yes, thank you. And then there's another question. If there are multiple convictions in the same county, but different courts, do we file 3 applications or just 1?
You would file 3 applications. So if you look on your iChat, sometimes the iChats can be wrong. So I always double check with an online register of actions or call the court clerk. You're filing in the court that they are convicted in. So always go right back there to file your applications. So multiple convictions occurred in that same court, they can all go on an application, but otherwise they would be different applications. I think there's an exception in Berrien where their circuit court and district courts are merged, but if you have a situation like that, I think it would be 1 application. All right, so your second type of application is the misdemeanor marijuana application. This is a much more simplified process. You're only going to be filing a copy with the court and sending a copy to the prosecuting attorney. And all that needs to be attached to this application is a copy of the certified copy of conviction. Next slide, please. So no hearing will be scheduled for this unless there is an objection within 60 days from the prosecutor. If there's no objection, the court must enter an order granting your motion. And if there is an objection, then a hearing will be scheduled within 30 days. And then the last type of application, as I said, I have not had to file one of these, is an application for victims of human trafficking. These types of applications must include a brief statement to show that the convictions were a result of the applicant being a victim of human trafficking. There's no waiting period, but beyond that, the application process is exactly the same as an application to set aside conviction. And with that, I can pass it over to Ashley.
All right, so then we go to the hearing date. And as Kelsey said, you have to schedule a separate hearing with every application you file. Some courts will allow you to set the hearing date before you file the documents, which is my preference because then I only have to send everything out once. However, sometimes the courts want you to file the documents first and then they will provide you with the hearing date after that. At that point, you would be sending out the application to every party that was listed, attorney general, prosecutor, state police, all that. And then you have to send a separate letter out with the proof of service with the hearing date on it, because you do need to provide each of those parties with the hearing date as well, so that they have the opportunity to object. Now, I've never had a court not schedule a hearing. I've only done a couple of these though. So I would just go on the assumption that the court would like a hearing to be scheduled, unless it's the misdemeanor or marijuana conviction, as we discussed earlier. And they are kind of pushing these out pretty far right now. So don't be surprised if you don't get a hearing date for 6 months. You can certainly try to ask for one nicely earlier, but in reality, with the amount of applications coming in, everyone's backed up. The Attorney General, Michigan State Police, prosecutor, they're all backed up with these applications. So don't be surprised, and make sure your client is aware that it may take some time. And you can expect to receive a response from the Michigan State Police, from the prosecutor's office, Office of Attorney General. Usually what I receive is just a letter saying, we received this application, we've checked it over, and it appears that they're eligible. Or it may say, we have no objection. Honestly, just read the document they send in. It's usually pretty form, and just keep an eye out if it says any sort of objection, because at that point you may need to get in contact with legal aid and discuss how to address that objection. I haven't had one yet, especially with this new law making such a large expansion. Everyone has actually been very kind in the entire legal system, and kind of excited to help people with this. So it should go pretty well. All right, next slide. You, again, what I mentioned before, make sure your client is aware that the prosecutor is allowed to object. You certainly get to apply for your expungement if you're eligible on paper, but I think we're all aware that sometimes the crime you're convicted of is nothing close to the crime you may have actually committed. And so because of that, the prosecutors may take a hard line and decide to object to that expungement, because maybe what the individual actually did, in some way, they believe that this crime should not be removed from your record. So make sure you really talk with your client to understand. I like to ask them all the facts as they say of what happened in their conviction, in the actual act that they did, and then what happened during their trial, and then what happened afterwards. Because we're all lawyers, that you really need to understand what you're going to this before. You don't want any surprises, and you don't want a surprise from the prosecutor. So make sure your client is aware. And at the end of the day, the judge does have the final decision to grant or deny. So make sure they are aware of that as well. That's where the description of your post-conviction behavior really comes into play. The one I did recently in 17th Circuit, blanking on the judge's name right now, but he essentially highlighted the 3 points that we all talk about: the barriers to employment, the barriers to housing, and the barriers to other services. So just make sure, I'm sure most of your clients will tell you that they've been unable to get a job because of their criminal record. They've been unable to get employment because of their criminal record. They couldn't be their child's chaperone, whatever it is. So if you're nervous about your client's conviction being expunged, make sure you really talk about how it's impacted their life and be prepared for that. And also be prepared to show how good they've been since they were convicted of this. And moving on to the next slide, kind of what I just said, the barriers are really important. The judges are aware of what these barriers are, but if you can really talk about it in specific details, humanize them before the judge. Because my last case, the guy's convictions were older than I am, and then the judge really resonated with him and how old these convictions are. And, they're more excited to grant these people a second chance. So when you're presenting your client, make sure that you are putting it in that light of, sure, maybe they made this mistake once, or maybe they were the victim of not having great legal representation at the time, or the victim of whatever, the 70s tough on crime. Make sure you talk about how your client's a real human, and these are real sacrifices that they had to put up with their entire life, despite serving their time and paying for their their fines. They still had to put up these ramifications their entire life. So make sure your client is prepared to share their life. And also, of course, the general questions of, you have no other crimes currently pending against you. You haven't been convicted of anything in the past 3 or 5 years, and you've paid off all your financial obligations. Those are a must in order to apply anyways. So double, triple check with your client that those are all taken care of. The judge may ask your client directly these questions, or they may ask you to ask your client these questions. So be prepared for either. If you would prefer to walk your client through, please tell me, have you done anything since you've been convicted? What has your life been like? Be prepared to do that yourself, but also know that the judge may walk them through that step by step themselves as well. Okay, and again, this is kind of what I already touched on, but just have your client think of anything that they've been engaged in that the judicial system would see as positive. So, charity work, being involved with their church, consistent employment, taking care of their family, raising their children. Again, it's really just everyday human activities. But it just goes to show that you're a productive member of society and you deserve to have this taken off your record so that you can continue to live, a full life without the shadows of this hanging over you. So, excuse me. I don't know if I cut out for a second there. I think that's it for me, so I'll pass it on to Kelsey.
Thank you, Ashley. Now we can just kind of talk about how we handle cases here at Legal Aid. If a client calls here asking for an expungement, the first thing we do is double check that they are eligible for services at Legal Aid. And then we move on and see if they're eligible for an expungement. We pre-screen and go through that whole process. And then we really want to make sure that the convictions that they are seeking to set aside are creating a barrier for them that's either impacting housing or employment. Those are our priority cases right now, or always. And we always pre-screen all clients for eligibility. We collect all documents, so the fingerprints, the certified copies of convictions, and their money orders. And it's also really great. We do have some funding available to help those clients that aren't able to cover costs for their $50 money orders or certified records, because the $50 and even $10 for a certified copy can be a huge barrier for some clients. That funding is county specific, so.
All right. Well, we went through that fairly quickly. Thank you both. So we have quite a bit of time for questions, and hopefully there will be some. I see that there's one already. Is there a filing fee for petitions? There is no filing fee with the court to file this, which just puts all those costs on the client generally. So the cost to get the certified records, the cost to get the fingerprinting, the cost to get an iChat if they do that on their own, that kind of thing. Let's see, it looks like there's another question. What do you put on the application if you're unable to get all of the information? Working on convictions from the early 80s, where many of the charge codes are missing on the certified convictions and iChat. Kelsey, I know you've dealt with that where a court doesn't even have a record of the conviction, although it shows up on the iChat. So maybe you can, answer that question and also talk about what you've done or options in that kind of situation.
Yeah, so if the court has no record of the conviction at all, there's no charge code on the iChat, I usually get a no record of conviction letter from the court and have them certify that. I'll attach it to the application and submit it with all the information I can get from the iChat. Sometimes it will just show up as dangerous drugs or something like that, and you don't really have a lot of information at all, so just put as much on there as you can, and everybody's pretty understanding. All parties are going to be pretty understanding that the court doesn't have a file and the iChat's not very sometimes reliable with information. So put as much on there as you can.
Thank you. Another question, if we already have a volunteer form on file with Legal Aid, do we need to fill out a new form, or can we add that we are available for expungements in some other manner? If you haven't filled one out in a while, you can fill fill that out again. If you filled one out more recently, just email me. I have a extensive spreadsheet of all the volunteers who are doing expungement work, and I'll add you to that. So you can do that either way. And on this, and speaking of that question, on this slide here, there is a volunteer form and a sign up form for the May 7th fair. And I will be sending this presentation out. I know you can't click on the form right now on the screen, but I'll be sending that information out. And both of those links were in the email that included the link for today's training. So that volunteer sign up form is our general sign up form to sign up to volunteer as a pro bono attorney for any type of case. And then the May 7th specific sign up form is just to help with that event, which will include pre-screening clients ahead of time on your own time, taking shifts at the fair itself on May 7th, and then taking cases after the event. So this is a fair where everybody is going to go through the legal aid process to qualify for our services. And the more attorneys we have that can take cases, we're going to get these people attorneys at the end of the fair as much as we can. We know that we probably won't be able to have an attorney for everyone that comes through the fair, but the more attorneys we have, the better. I know the city of Grand Rapids is hosting a fair a week from tomorrow, I believe, on April 2nd, and they had about 400 people register for that. So if you're interested in helping them, reach out to me and I can send you their volunteer form as well. But at our event at the end, we're going to go through and similar to what Kelsey talked about in looking at priorities, we're going to look at those folks that need our help the most and then get those people attorneys as quickly as we can. All right. And then another question. There are, I believe, 4 rows on the application to list the convictions. Can there be more than 4 convictions listed on the same application? Kelsey, do you want to answer that one?
Yes, there can be. I usually just print out page 1 again and put as many convictions as I need on there. You can keep printing page 1. So yes.
One of the things I did want to, end this too with is talking about this May 7th event. Ashley has volunteered at several of the fairs that we've had. We had a fair similar to the May 7th event that we're holding last August. It was the same location. I know some of you volunteered with us there, and I'm happy to see you back, and hopefully we'll see you on May 7th. But Ashley, do you mind just talking about kind of your experience with that and what you did at that fair?
Sure. Making sure I'm not on mute. Okay. Yeah, the fairs are a mix of pre-application people and walk-ins. So be prepared for that. Sometimes we already have their iChats pulled. Sometimes they pull their iChats on site. Almost everybody, as in the clients who show up, have no idea how the process works. They don't know what they're doing. So you really have to pull out your counselor hat for that, for these sort of events. People do get upset, obviously, when you tell them that they're not eligible. So make sure when you let me back up. Essentially what happens, the attorneys sit down at a table in the back of the fair. People walk up to the front of the fair, check in, and then when it's their turn, when their iChat has been pulled, they get sent to an attorney. They'll sit down across from you at a table. You'll let them know you have your iChat in front of them, and you'll look it over to see if they're eligible. You pull up the legislature website, however you look up criminal codes, and you determine if their crime is eligible. And if it is, you want to double check with them. Is there anything that may not be listed on here? Because remember what I said, sometimes the iChat's not entirely accurate, and you could be completely ineligible for expungement in certain circumstances. So make sure you're clear with that. If you determine they're eligible, you fill out the application on the spot with them. Usually then there's a table where they can go over and get fingerprinted. There's a printer so they can get all their copies. But what usually happens is you send them home with all of that. You usually don't at that point take it for them. It might change a little bit. Noah saying that, we're trying to get attorneys assigned, but usually you send them home and you try to give them as much clear instructions as possible. Sometimes I even pull out a piece of paper and just write, number one, send this to this person. Number two, send to this person. Just remember that to us, this is so incredibly easy. Truly, this is very easy for any lawyer, but for a normal person, it's terrifying and confusing. So just being as clear and direct and concise as you can be is really helpful. And then they just bring on the next one.
Yeah. And it's really important, and we're hoping to get as many people pre-registered as we can, because it's just so much easier to help people when we've been able to pre-screen them and determine that they're eligible ahead of time. If we have the capacity, we will take walk-ins, but we really are trying to do this as a pre-registered process. I see there's a hand up, but first there was a chat that came in a few minutes ago, so I want to cover that. Only one set of fingerprints and only a $50 processing fee is needed in total, even if there are convictions across multiple courts. Is that correct? This is one of the many variations in this that makes it difficult. We have definitely had people send in multiple applications with one $50 check, and it gets processed and it's fine. When we have called, and I know Kelsey has spoken to the Michigan State Police, every conversation they have said, we require $50 with each application. So that's what we do, because that's what they've told us they require. Again, I have not seen them being sent back. So I don't know why that is. I don't know if that's because certain people, it depends on who opens the file, and some people, they just process it, or if they're just trying to get things through. We have had applications sent back for other reasons. So it's one of those things that's just difficult. And with all the variety of what different courts are doing, it just adds complication. I know, Ashley was talking about the different way courts have hearings. There is one court that doesn't hold hearings on general applications unless there is a victim in the case or an objection, which would be great and would make everything move more smoothly. But that's the rare exception to that. So one of the things of taking a case through legal aid is, we've done a lot of these, and so we hopefully know a lot of these difficulties and inconsistencies, and we can help you with that. I just want to make sure to let everybody know, as Ashley talked about, if there are objections or if there are things that come up, if you take a case through legal aid, we're here throughout that process to help you to answer questions, to do what we can to help kind of figure these things out if stuff happens, because it will. Things happen, things pop up on criminal background checks that are done through the state police once you file, that are not on the iChat, and just knowing how to deal with that is not always easy. There are a few more questions in the chat, but I'm going to go to Brian. You have your hand up if you want to unmute and just go ahead and ask your question.
Yeah, thanks, Noah. This is kind of related to what you just mentioned, the inconsistencies on the call on Wednesday. You had mentioned different courts and different judges are looking at the language of the waiting period differently. I know when I've done pre-screens in the past, it could change the eligibility depending on which way the particular court's going to look at that waiting period. How should we, if we're doing pre-screens or if we're in one of the fairs live, like how should we deal with that aspect? Do you guys know enough about the different courts and judges to kind of advise on which way to look at the waiting periods, or yeah?
Yeah. So specifically to like the May 7th fair, I can't speak to other events that other people are organizing, but there will be people there to help answer that kind of question. So there is a general consensus, which is that the waiting period is looking back from the time of the application. So my recommendation would be that you start there. If we know that, there's a specific court that looks at it differently, we'll flag that. We'll look at that, but it's not like it's 60-40. It's more like 99-1 as far as what we've seen. So there is a general consensus. So it's just easier to use that, that interpretation of it. And hopefully we'll have some better answers on that soon. I know that there have been some appeals filed in some of these cases. So we're hoping that there'll be some clarification either through an appeal or a rewriting of the law. I know that some of the legislatures have been looking at trying to cleaning up some of those inconsistencies in the law. So hopefully that will be resolved soon. But for now, just, most courts have the same interpretation. So it's easier just to go that route. And if somebody falls into the minority exception, we'll try to flag that.
Cool. Thank you.
You're welcome. Okay, so let's see. Another question in the chat. When clients ask, won't my record be expunged automatically in 2023? So there are a couple parts to that. There are a lot of things that will never be automatically expunged that qualify for an application. So there are a lot of, the application for an expungement is never going away. So that's part of that issue. There's also the issue of the time frame. So right now, if somebody has a misdemeanor from 2019, the beginning of January of 2019, that they got off probation for, it's been 3 years since then, they're eligible. If they wait till next year, the waiting period for automatic expungement of a misdemeanor is 7 years. So they're not going to be eligible until 2026. So you might have people that want to file just to, jump the line, not jump the line, but get the shorter waiting period and get that expunged. And that's still going to be something that they can do. If they want to wait and they'll be eligible in 2023, great. The other negative of that is it's expected to go into effect in 2023. I would not guarantee to anybody that as of April 2023, it's actually going to happen. Our court systems, they don't use the same systems. I don't even know how they're going to figure all this out with this complicated law and the technology. And they can ask for extensions. The law allows them to ask for extensions. So it could be longer. But if somebody wants to wait for 2023, I would just counsel them on the drawbacks that could be involved with that. But that would be fine. How do we check if courts, fines, and fees have been paid? Some of the online court searches show that. If not, you can generally call and ask the court and they will provide that information. But those are the two ways. And there have been some instances where people have been able to file expungements without all those things being paid. We definitely recommend that people pay it off, but if they're just unable to do that, if they have been making regular payments, maybe that would be enough. I mean, it's really up to the judge. That's where the discretion really comes into play. They can say no because of that. So it's not an easy black and white issue. Another question that has come in the chat. Let's see. What impact does a conviction from out of state have on your ability to get expungement here on Michigan cases? Specifically, if you have over 3 felonies with the extra conviction being out of state, does that affect ability to get expunged? Kelsey, you want to take that one?
Yeah, so I think that my first question would be, when did the out-of-state conviction occur? Because if they have 3 felonies, they have a 7-year waiting period to apply for expungement. So if it occurred within the past 7 years, I would flag it as a problem because it occurred in the waiting period, and they can have no criminal convictions within their applicable waiting period. If it occurred 20 years ago, I wouldn't count it as a problem because the way the statute's written, implies that we're only looking at convictions within the state of Michigan. Would you agree with that, Noah?
I think so. Yeah. The one I'm not sure about is, so if the person has three felonies in Michigan and then let's say one felony outside of the state, does that mean they're ineligible? I don't think so.
No,
So
I would count, I would say that person's eligible as long
Yeah.
as that is an old conviction in out of state.
so generally the out of state conviction, our reading of that is that it impacts the timing, but not the number of crimes that you can have expunged.
Correct.
Okay. Are there successful appeals of a judicial denial of an application? I mean, well, Kelsey, you are familiar with that appellate case.
For the new expungement law, we are kind of waiting to see the outcome on multiple appeals of denial. So stay tuned, I guess, on that one.
But there have been successful appeals of expungement law in general, going back before the clean slate law. So there's the case. I don't remember the name of the case, Kelsey. I think you know that that talks about what a judge can, while they have discretion, their discretion is limited. So
Right. I mean, there's cases that you always want to have in your back pocket that really, if you're going in for an expungement, People v. Rosen, a judge cannot deny an expungement based on the nature of an offense alone. Always keep that in your back pocket if you're going in for an expungement, just in case they start throwing around nature of the offense. People v. Van Heck, the remedial statutes that are remedial in nature should be construed liberally in favor of their remedial policy that's geared towards expungement. I would say keep that in your back pocket if you're going forward and things kind of are starting looking like they're going downhill. So those were appellate cases.
And if I could interject and add, as someone again who doesn't do any sort of criminal law, the extent that legal aid is there to help you with any question is very true. I have emailed Noah many times. If I ever have a little bit of a question, I email him and he always has an answer for me. So don't be afraid to reach out.
Yeah, I'm always happy to help. And if I don't know the answer, Kelsey does, because she does nothing but expungement and she's knows it top to bottom. Okay, I'm not seeing any more questions coming in on the chat. So if there are more, feel free. We still have a few minutes left. Again, I'm going to be sending out some more follow-up information next week. We have recorded these. I'm not going to send out the recordings, but if you need it for some reason, just let me know. It'll take me a little bit longer to get the recordings in order, but I'll send out the slides and then these links to the sign up forms. They're both active. So, and we're definitely looking for more people for May 7th and just to take cases in general. We get cases every day. Question about Kalamazoo fairs. I'm not aware of any Kalamazoo fairs that are going on. We had a really good one last August, but I don't know of another one happening. There is a project in Kalamazoo with the Kalamazoo Bar Association and the Michigan Works and the Public Defender's Office, who they're trying to help folks go through this process on their own. So I know the attorneys with the Bar Association are really trying to review a lot of applications. They have a huge backlog of applications of people that are interested in this. So if you're a member of the Kalamazoo Bar Association, you can reach out to them to get involved with that project. All right, so I'm not seeing any other questions. So thank you, Kelsey, and thank you, Ashley. I hope to see everybody May 7th. At the Center for Community Transformation. It's going to be a great event and we need lots of help. So I appreciate all of you that have come out to our events before, and hopefully we'll we'll see you at events in the future as well. So thanks a lot and have a great weekend, everybody.